Coming up next on Insights on PBS Hawaii, should we have the right to decide how we die? You didn't bring it over from the mainland. Aloha and welcome to Insights on PBS Hawaii. I'm Dan Boylan. Advocates for physician-assisted suicide argue that terminally ill patients should be allowed to end their lives before they're too incapacitated to make the decision themselves. But recently, Attorney General David Louie warned that any doctor who knowingly prescribes a lethal drug cocktail to suicidal patients can be charged with manslaughter. Is there a middle ground where patients can find compassionate care and meet death with dignity? Should we have the right to decide how we die? We invite you to join our conversation by calling, emailing, or tweeting your questions and comments. Now to our panel. David Louie has been the state's Attorney General since 2011. He was appointed to a 4-year term by Hawaii Governor Neil Abercrombie. Barbara Coombs Lee is the president of Compassion and Choices, a national nonprofit organization that supports aid in dying. She practiced as a nurse and a physician assistant for 25 years before beginning a career in law and health policy. Jim Pietsch is the director of the University of Hawaii Elder Law Program. In 1996, Jim served on then-Governor Ben Cayetano's Blue Ribbon Panel on Living with Dignity. Dr. Emese Somogyi, how'd I do?
Not good.
Do it again. Do it for me. Do it again.
Emese Somogyi.
Emese Somogyi. Okay. Practices palliative care and geriatric medicine at Castle Medical Center. She is also a member of Kokuamau, Hawaii's hospice and palliative care organization. Barbara, you've already taken me to task, so please define some things for us you think that we've messed up with.
I think it's important for listeners, for viewers, to understand that there is a big difference. There's a legal difference and certainly a psychological difference between suicide and aid in dying. We all are interested in suicide prevention. People who are terminally ill and making a rational decision about how they want their lives to end, however, are not suicidal in the psychological meaning of the term. They're not irrational, they're not spontaneous or engaged in acting out behavior. They're not alienated, they're not depressed, they're not mentally disturbed, they don't have disordered thinking. They are, though, very interested in a kind of a preservation of the self, and preservation of the values and the beliefs of their lifetime. And in the interest of that preservation, they have a real interest in dying peacefully, dying in the comfort of their home, dying in the arms of their loved ones, dying in a way that does not rob their lives of the meaning and the value that it has. So I would say causing a suicide, in Hawaii, of course, there is no assisted suicide law. There's only a causing suicide law, manslaughter. I would say that that's the law of a crime, the words of a crime, language of a crime. And then there's language of medical practice, legitimate medical practice. When we talk about physicians doing surgery, we don't talk about assault or mutilation or stabbing because those are legitimate medical practices. So it's very confusing if you use the language of a crime to describe a medical practice, the medical practice of giving a prescription for life-ending medication with the purpose of empowering people, giving them control and comfort, giving them some sense of dignity at the end of life. Has nothing to do with suicide.
I am chastened, I want you to know. David, why did you issue this warning? As I understand it, there was at least one lawyer and someone else who argued that we already have a law that says it's all right for physicians to assist and help people in their last moments. But you said that you immediately warned that you'll prosecute them.
Absolutely. You know, Dan, and with all due respect to Barbara, it is not a legitimate medical practice here in the state of Hawaii to assist somebody in dying. It is a crime. Our statute is very clear. Section 707-702, it's manslaughter. Manslaughter is defined as when somebody intentionally causes another person to commit suicide. It's very clear. The other statute that makes a difference here is 32941, which says you cannot prescribe, a doctor cannot prescribe or administer a controlled substance, narcotic, that would kill somebody unless they have a bona fide patient-physician relationship, which means you have to have a in-person physical exam, and you prescribe that medication for a legitimate medical purpose. It's not a legitimate medical purpose in the state of Hawaii to kill somebody. If I was to give you a loaded gun and put it right there in front of you, and you want to die, and I put that right there, and I say, hey, Dan, you can do that, and you pick that up, and you blow your brains out, there is nobody who would say that I had not assisted you in dying. If I pulled out a stick of dynamite with a little button on it that was going to blow you up, and I said, here, Dan, go ahead, go right ahead. I'm going to walk out of the room, and you blew yourself up. There is nobody who would say that I had not assisted you in killing yourself. And so if a physician wants to prescribe a lethal dose of medicine for somebody and say, oh, well, if you take it, you might die. If you don't take it, you won't. That's the same thing. It's not a legitimate medical purpose. So any physician who does that, quite frankly, is in danger of being charged with manslaughter and of violating their patient-physician relationship. And the reason I issued that opinion, Dan, was there were ads being placed here. Compassion and Choices placed a bunch of ads. They had a lawyer from the mainland, not even a lawyer from here, who said, oh, it's perfectly legal in Hawaii to go get a doctor to prescribe you a lethal dose of medicine. Unfortunately, I disagree. And it's not even clear. I think it's a very black and white legal question here in the state of Hawaii. If you want to have assisted suicide, you can do it. Go to the legislature, just like Oregon does. Other states have done that, but you have to go through the proper process.
But Jim, I know that my wife and I recently made out a will, and the very fine lawyer who helped us with that said the most important thing you have to do is this advance notice directive of how you want your life to end. But it cannot include saying anything that would indicate that I'm going to do myself in, or that I would like a doctor to prescribe me with sufficient things to do myself in, right? I can't do that.
Sure you can.
You can?
Well, that doesn't mean the doctor will follow it. Doesn't mean the doctor has to follow it. But the Uniform Healthcare Decisions Act is actually quite neutral on this subject. It says that this statute does not prohibit, does not allow. It's more neutral unless some other statute implicates that wrongdoing or the support of it. As the Attorney General is indicating, yeah, if there's really a statute there that says that this practice is illegal, then the Uniform Healthcare Decisions Act would not be applicable under those circumstances. But I know a lot of people are putting it in their advance directives for future use in the event Hawaii has a statute that goes into effect, that in the future, if it's clear, then certainly. But the question comes back to whether or not this manslaughter statute is in fact so black and white. I talked to a former prosecutor, a city and county prosecutor, and he said, oh, yeah, well, maybe we should change the law to make it really, really clear, because what is causing a person to commit suicide, and what is suicide? Is this suicide at all? Mm-hmm. Is it causing, and then we add into the whole mix of things, the free will of the individual. If we put this, watch out, Dan, this is arsenic, and we sit by.
At least it's not a pistol the way this guy would have me blow my brains out.
But so it's more nuanced, and then on one side we have individuals who say, absolutely, we have the right in Hawaii, and then on the other side, absolutely, we don't have the right. And then there are a bunch of statutes. Hawaii has developed statutes in fits and starts, and you piece together things that are not quite. The manslaughter statute, when it was enacted by the legislature, they didn't think about physician aid and dying. The 1896 and 1909 laws, where it indicates a practice of medicine where you are authorized to give any remedial agent to an individual. Yeah, that's been around for over 100 years, and the Attorney General has in his opinion, has discussed that point. And they weren't thinking about physician aid in dying. They were thinking about tuberculosis. They were talking about other things. But we don't have any clear law one way or the other, in my opinion. And I don't think that the intention of the legislature is to monitor the practice of medicine. Right. There's an interesting case in Montana where the Baxter case, where they were looking at the Constitution of Montana. It's not the same as in Hawaii, because they have not only a privacy provision that we have in our statute, but also a dignity provision. But they looked at the constitutional issues. They looked at, is there really anything to prohibit a doctor to do this under the practice as some of the other states have done? Hawaii is, in my opinion, isn't clear at all on either side. And then what is the practice of medicine?
So I'd like to put it in context, if I could, very quickly, and in context about just how aggressive that opinion is, and put it in the context of the whole United States. A prosecution of a physician for writing a prescription and handing it to a dying, suffering person and saying, I hope that you never have to take this, but I know that having it will improve the quality of your life and it will give you a lot of comfort. Prosecuting a physician like that for manslaughter has not only never occurred in Hawaii, it has never occurred anywhere in the nation. No physician in the nation anywhere has faced a prosecution for writing a prescription for medication and handing it to an eligible terminally ill person. It just seems so incongruous that in Hawaii, the place of such tolerance and compassion, that would be the stance, and that this would be the first place in the country that ever happened.
Michelle, I want to ask you, okay, these guys have got me ready to either do myself in or whatever. If I came to you and said, I'm tired of fighting this disease, what would you say to me? As someone who's telling people that we can make life easier for you at the end, or how would you deal with it?
I would ask you a lot of questions. Sit down, make time. Try to understand your situation and what's causing you such degree of suffering. And I would use all my professional skills that I honed over the past 20 years working with elderly, seriously and terminally ill patients to relieve that suffering.
But if it's really pain, not depression, if it's really pain and a mix of pain and depression, please help me. What are you going to tell me?
That pain is treatable the majority of time. 99% of the time, pain can be relieved.
But what if I want to say, my response is, I don't want to burden my family. I don't want them to have to deal, or my poor wife having to, hold my hand and wipe me and all that wonderful stuff. Wouldn't you go along with the idea if I said, well, I can get Dr. So-and-so to give me so-and-so, and wouldn't you go along with that?
No, it's very tempting to pass judgment and say, just because you're terminally ill, that your life is not worthwhile, that there are no good solutions, that you are a burden. That's not a message I try to give my patients. I would try to work with you, involve doctors, chaplains, nurses, social workers, so that maybe you can, human beings are capable of tremendous development. And we do develop through the life cycle to the moment we die. And that end of life is an incredibly important time where humans look at their life, assess it, and gain some insights, gain some closures.
But it's my life,
Right.
isn't it?
Exactly, exactly. The reason that physician-assisted suicide typically gains approval in polls, in general physician groups, is because it offers this idea that there is a very simple solution to a very, very scary and very complex problem. But the majority...
Absolutely agree.
Thank you.
Absolutely agree with her. This is a very complex problem. And the states that have allowed this, Oregon has...
Washington.
Yeah, they have very complex regimes. They have training, they have requirements. They're very strict. Elderly people, terminally ill people are vulnerable. They are so subject to abuse by a family member who might want to inherit, by a caregiver who might want to inherit or wants to move on or do something like that. And so you have to have these safeguards. The state of Hawaii has considered this at the legislature. And I'm not against this type of regime. If the people of Hawaii want to do it, I say, fine, let's just do it the right way. The legislature previously considered it. They did not do this.
They came awfully close.
That's fine, but they didn't do it. You know, the Supreme...
Within 3 votes in the state Senate, right? The legislature passed, the House passed it in 2002, right? Sure. Yeah, help me out with the history of this.
And then they had the votes in the Senate, and then what happens? Pressure on the legislators, and that's the political process.
That's the political process, and they didn't do it.
And it you know, we've had a recent experience with success in a program with the marriage equality. That was quite controversial too. Hawaii was the first state to authorize abortion. And so Hawaii was a progressive state, and then it sort of stalls. And then where are we now? We don't really know where we are. We know that most people, most of my clients would say that I want to have some assurance that I can stay in control over my life at the end. We thought, well, maybe advanced directives, then we can certainly make sure that those are followed. But in the past year, even that has come under question, where we had a famous case at Queens in the past year, where the individual's advanced directive, the doctor said, okay, we're going to follow the advanced directive, the family gets involved, goes to court, nothing ever gets resolved, and people are really discomforted by that they won't be in control.
People want to be in control, and they want the government out.
Yes.
I mean, that's one of the lessons, I think, to learn from Oregon and Washington, because as the practice of aid in dying evolves and moves from state to state, you know, as the Supreme Court said, in the laboratory of the states, it's not going to be done exactly the same way in every state. That's why we have the laboratory of the state, so that we can have one state try it out. How does it work? Is it beneficial? Is it subject to abuse? What kind of people use it? What kind of physicians? And Oregon has been that. 15 years of careful data recording in Oregon. Then it moves to Washington. Then it moves to Montana, where there are no statutory requirements for reporting. Then it moves to Vermont, where the Vermont legislature said, well, we'd like to have 3 years where there's some reporting so that we know kind of the way the practice is moving. But after 3 years, government out. This is private, this is personal, between patients and physicians. Hawaii could be a leader. Hawaii could be a leader in the evolution of this practice.
Speaking of data, what is the most recent data? How many people went through the legal process in the state of Oregon in a year?
Most recent data was 115 requests, completed requests, and as you know, the request process is quite onerous, and 77 people ingested the medication. And that discrepancy between requesting and obtaining and ingesting exactly proves the point of the purpose of the prescription not being to cause the death. The purpose of the prescription is a palliative purpose. It's to give comfort, empowerment, quality of life. People are transformed when that aching worry about how they're going to die and what experience they're going to leave their loved ones. Perhaps 99% of people, as you say, do get complete relief with palliative care, and palliative care is excellent. Hospice is the gold standard.
I would like to take
but
the word back.
But even if there's only 1% of people for whom their suffering cannot be alleviated, 100% of people worry about being in the 1%. So they need that kind of assurance.
Yes. So again, just to create some more context, 70 people in Oregon, which is a state of about 3 million, am I correct? So, and that built up over about 15 years of practice. I think initially it was maybe 30 people a year. If we use those numbers to calculate how many people annually would use this law to their benefit in the state of Hawaii, by benefit I define that they actually take the medication, it would be 8 to 35 people. And as I said, I'm a physician, I'm also a teacher, I'm a community activist promoting care at the end of life. I spent a lot of time considering this issue in the past 15 or 20 years. And the reason I really came down on the side of that legalization is really not where we should concentrate our effort is because I decided to side with the 99% and ask myself, what can I do for the 99%? And I'm really baffled by how polarizing this issue remained after 20 years of debating it, how tremendous amount of money and time and effort and political debate goes into it. And in the meantime, if we look at, yes, we made improvements in how we care for terminally ill people, but they are not great. There are some very scary data, and when we talk about choices, and I know I'm here with 3 lawyers, but when I think about...
This is always a problem. I've had the problem here before.
What I'm trying to say is that I really look at the choices people don't have, and the way the state of healthcare is. The choices people don't have is, for example, 84% of end-stage cancer patients go to the emergency room at least once in the last 6 months for unrelieved symptoms, pain, emotional, physical suffering. 1 out of 3 goes to the last 2 weeks of their life. Is that a way you want to be cared for at the end of life? I don't think so. You don't want to wait 4 hours in an emergency room in pain, dying of cancer. So, this debate here we are having. But, I wish it wasn't about the rights, Jim.
But Dan mentioned that in 1996, Governor Cayetano, that's a long time ago, set up this panel. Here it is, and it has the same results. People are dying poorly. Let's help them. They had unanimous consent on most of the findings, which included palliative care, advanced directives, spiritual assistance at the end of life, education to the public and in universities. But still, people were dying very poorly.
I need to cut in, Jim. In 1996, there was no palliative care in the state of Hawaii. I was the first physician recruited by the dean of the medical school to develop this area in 2000.
But why Aquan McElrath, the retired social worker and an advocate, was behind the establishment of this blueprint panel.
Over the years, we've come to call her the great,
the late great.
Yes.
But her mantra was, but why impose this on me? Why can't I choose to go forward in this direction? And we still have people dying in pain. We still see not great palliative care on occasion. And the point that I was going to make was that they suggested the non-unanimous recommendation was to authorize the practice, and they said it wouldn't affect that many people, but people would have the comfort that in case something really, really went bad, that you would have it. There's a parallel. Three young special forces operators were jumping into Nazi-occupied France. And they were coordinating D-Day, they were coordinating the southern France invasion, so they had a lot of information. They each had L pills. And the three of them that I knew were Catholics. And they said, what should we do? And they said, if you're captured, can you withstand it? Now, nobody ordered them to take the pill. It was a choice. But then they had great comfort knowing that, it was there just in case.
Right.
And
that's fine. That's fine to have the process. But if we're going to have the process, let's do it appropriately. Let's do it through the legislature. You can have another study. Maybe the time is right that some people want to do it. What I object to is people coming down and advertising here that says you can do it now, because I absolutely disagree with it. And somebody who attempts to do that right now has none of the safeguards that we put in Oregon, that in Washington, and many of these other states, has none of the requirements that make sure that there is a sound medical decision with appropriate counseling, with good thought, with time to reflect on these things. Right now, there's just no safeguards.
That's not true. It has all the safeguards that medical practice has. Medical practice is the most regulated profession there is, and there are clinical guidelines, there are practice guidelines, there is a standard of care.
Which they may choose to abide by or not choose. But if you have a law, then you absolutely have to abide by it.
But you know that medical practice is not governed by statute. When palliative care physicians decided that terminal sedation was going to be a new palliative care modality, they didn't go to the legislature and say, please, legislators, give us permission to institute a new modality of terminal sedation.
That's because they weren't killing people.
Whoa. Let's go to, help me with terminal sedation.
Okay. First of all, here I have to make some corrections about the term. We don't use it terminal sedation anymore. We use the term palliative sedation. And what it really means is that you are, when you get to the point that you exhausted all existing resources for relieving physical suffering, such as pain or severe agitation, that you are going to use sedation to make the patient unconscious to some extent, for a limited or a longer period of time, to relieve their symptoms with the intention of relieving the symptoms that no smaller measure relieve. The reason we call it oftentimes, or used to call it, terminal sedation is because it's a step that's often used at the very, very end stage of life. And because in the course of sedation, oftentimes people die.
And during that period, of course, if the individual does have an advance directive, says I do not want tube feeding, then you don't provide tube feeding, and it just takes a lot longer than the old-fashioned L pill that the Army had at one time. No, but now it would be more of a cocktail.
Well, right. What wasn't mentioned was the very first name for terminal sedation was slow euthanasia. That's when it was first introduced, that is sedation to unconsciousness for unmanageable symptoms and the withholding of food and fluids. It was called slow euthanasia. But it became normalized in medical practice without any statutory rigmarole. How many people die every year intentionally to die, intending to die, by stopping their feeding tube, by withdrawing their insulin, by withdrawing respirators? The legislature doesn't have a role to play in telling doctors exactly what modalities can be offered for comfort and to improve the quality of life and to manage the dying process. The vast majority of people, 90% of the people of voters of Hawaii, say, keep the government out of this issue.
I absolutely disagree that the government has no role. If you want to kill somebody and giving somebody a lethal dose and them taking it so that they can die, that's killing them. the United States Supreme Court has said that. But if you're going to do that, if you're going to kill people, then we need to do it with dignity. You need to do it with a proper safeguards. You need to do it with absolute legal requirements, because we're talking about ending people's lives.
But
it is very different.
Isn't our argument academic? The argument that we're having here right now, isn't it academic?
Then I mean,
I can get, but I'm an academic too.
I know. Two professors.
Yeah, we can handle this. Isn't it academic? Because I'm almost certain that I've got enough pills in my medicine cabinet right now to put myself away. I'm almost certain, but I'm not a physician, right? I'm not a physician. Well, and so if I do want to put myself away, I want to make really sure I do it.
But why should the physician be the gatekeeper necessarily?
Well,
but they
the gatekeeper is the one with the access to medications to make it peaceful. You could kneel in front of a train, you could jump from a balcony, and people do that all the time.
I could use that gun of David's.
You could use the David's gun, that's right.
And we've had a series of botched suicide attempts because of the terminal condition. There was no hope, and so that's what the Blue Ribbon Panel was trying to go forward. But I had suggested that we continue the work a little longer, and a couple of folks that are on it, several have died since then, but you know, maybe we do need to look at where we are now and what the process should be. Now, Montana has an interesting parallel to Hawaii in that there are no guidelines in Montana. They wanted to get guidelines, but the Supreme Court says no, there's no real prohibition against physician-assisted
And they based it on the Healthcare Decisions Act, not the Constitution of Montana. And
even
so
though the lower court attempted to, you know, raise the constitutional issues, but the Montana Supreme Court says, well, we're not going to get to that constitutional decision. We're going to look at, are there really any laws prohibiting physician aid in dying, medically assisted dying, and that's why I'm so happy we have the Attorney General here, because do we really? And again, when I talked to the prosecutor 10 years ago on the same issue, he said, well, in order to put a person on notice on the criminal code, you know, what would a jury do? What would a judge do without a jury? And it's not really that clear that this applies to physician-assisted suicide.
It's never that clear in any criminal trial, but I'll tell you this. If a physician gives a lethal cocktail to somebody and they kill themselves and they get prosecuted, I'm sure 12 good citizens of the state of Hawaii will say that violated the law.
Well, and would you prosecute?
Absolutely.
You would prosecute?
I would prosecute.
Would the panel address the pain patients may be experiencing? Now that's where you come in, right? If someone comes to you with pain, really pain that they can't handle it anymore, they feel they can't, what are you going to tell them?
As I said, pain is very treatable, highly treatable. It takes a lot of expertise. I also would like to remind you of something that Barbara was talking about. Most people who pursue physician-assisted suicide don't do it because of physical symptoms. It's really because of the existential suffering they are experiencing.
Ron says, should someone be allowed to end their life if they are at constant, tremendous mental anguish that has not responded to treatment? Now, do you deal with the mental part of it too?
That's a very big part, but we actually never gave a definition of palliative care, and it might be useful because most people are not very familiar. It's a new medical subspecialty that
we'll never get there.
Yes.
We'll try.
Okay. It's a new medical specialty, and the focus is on improving the quality of life, preventing and relieving suffering in people who have some sort of an advanced, serious, or terminal illness. Palliative care is different from hospice. It's a confusing topic for a lot of people in the sense that palliative care is used with treatments that are directed at the disease itself, and it can be used at any stage of the disease. And when I speak about suffering, I'm going to use my favorite definition of suffering by Eric Cassell, which means that suffering is caused by something that disrupts a personal sense of being a whole.
Yes, exactly. And that's exactly why an aid in dying prescription can be so palliative. A physician doesn't hand it to someone and say, I hope you kill yourself. In fact, a physician says, you know, I hope you don't need this. And up to a half, 1 year, more than half of the people in Oregon who received a prescription did not ingest the medication. It's the people who benefit from it. I wouldn't define it so narrowly and say only those people who take the medication. I would define who benefits the 1 in 6. 1 in 6, that's a lot of people who use the law to have an open, honest conversation with their loved ones about, look, I'm dying.
Amasha, you were going to say something else. I thought you were going to say something else. You weren't?
I was just going to emphasize that approaching patients as whole people and having skills not just with the physical, but the emotional, spiritual, and psychological part is very important.
Was with suffering. And some of us suggested, why don't we study this more? But the Blue Ribbon panel was tired, and they said, no, we can't take it any longer, and so let's just disband. But I think it should be brought up. Now, I have an interesting technical question. When does the crime happen? When does the crime happen?
It happens when you, when the person dies.
And see, that's the
and
point.
It happens
what if they never take it?
Well, if they never take it, then fine.
There's no crime.
There's no crime.
That's right.
And what if they attempt?
But if they do die?
What if they attempt and they don't die? There's no such thing as attempted manslaughter.
Jim, what about, Barbara has a question. What about the room for abuse? For example, what about family members that might want to get rid of an aging person and talk them into dying? It happens
more than you think, and I concur that this is a tremendous issue for the state. This is a tremendous, and the Supreme Court did address the interests that the state have: preservation of life, protection of vulnerable populations, including the elderly, the disabled, people who are vulnerable for financial exploitation. Absolutely, and I completely agree with that, because we very often get an older person whose family is telling them, why don't you just die? And they make it easier on them. So absolutely. So the technical side apart, the reality of life is out there. It's not pretty,
right.
And you do deserve the protections.
I agree with that, but I would say that the vulnerabilities exist mostly with the modalities that advance the time of death that are already done hundreds of times every day in every state of the union. It's much easier to abuse the withdrawal of a feeding tube, the withdrawal of a ventilator, the discontinuation of dialysis, where the patient is probably unconscious, not compos mentis, not making a contemporaneous decision. I would say that aid in dying is the least subject to abuse, because it requires a competent terminally ill patient, self-directed, autonomously making a decision and taking a voluntary act of ingesting the medication if and only if they find their suffering to be unbearable.
So there needs to be proper safeguards, and that's why you need to go through the legislative process so you have safeguards. Now, if Montana wants to say we're not going to have safeguards, that's up to them.
Should we have those same safeguards for withdrawing a feeding tube?
But I absolutely disagree that we should not have safeguards. And I will tell you, yes, withdrawing a feeding tube is very different from affirmatively ingesting a cocktail that will kill you. Our Supreme Court has said if you prescribe medication and the person takes that medication and they die, you have killed that person. That's the United States Supreme Court. And I think it's that's the Vacco versus Quill case.
They say you have killed that person?
If a patient ingests lethal medication prescribed by a physician, he is killed by that medication. That's a direct quote.
Well, he's killed
by the medication. That's what they said. That is different from saying that you have killed it, isn't it?
I think the physician is killed, and I'm happy to take that into a jury.
The physician is killing?
Yes.
David in Hilo says, assisted suicide is not something that comes from a native Hawaiian background because we take care of our kupuna. This is Western influence. To the woman who said that no one has ever been prosecuted for assisted suicide, I want to remind her of Jack Kevorkian.
And
in
wonderful, wonderful example, wonderful example. Jack Kevorkian never wrote a prescription for medication and handed it to a terminally ill patient, and that's what I said no one has ever been prosecuted for. And talk about the jury of 12 people trying to find one of those physicians, a good physician, with a good physician-patient relationship, writing a prescription for a suffering person. The likelihood of a jury convicting that person, they couldn't even convict Jack Kevorkian, a provocateur who administered the medication himself. 3 acquittals, a mistrial. Finally, they got him, he was in jail because he essentially did it on national TV.
Moses in Nanakuli. My dad was in hospice and it took 11 days to die. He was deteriorating and it only caused him to suffer. So I think it should be left up to the person. You know, someone sent us, somebody said, all of us are, there's not a religious person here. There's not someone who represents organized religion. And there isn't. What about, and you know, you've talked about the existential problem. Let's talk about the existential problem of, is human life divinely created and divinely kept, and should we be allowed to, or should the medical profession be allowed to prescribe ways for us to act unnaturally and do ourselves in?
Suicide is against every religious precept, Dan.
I
think the Catholic Church, the Presbyterians, the Protestants, they all condemn suicide.
Well, it's not a condemnation. In the modern world, it's more, if it's a true suicide, and then that's the issue. Is this suicide to begin with? But it's more of a mental health issue. We have mental health statutes, but we had 4 religious persons on the Blue Ribbon panel, and 2 voted for, 2 voted against. So it's not that clear, or 3 to 1, but at least 1 voted in favor. I think that this would not rob the right of a person to choose how they die and when they die, would not rob a religious person of any of these rights. And again, as Aquan might say, why should your religion be imposed upon me? Now, I believe that there should be safeguards, that religious and cultural practices should be followed by people who have those beliefs, and the doctor should not be required to follow through on any of these things. But for those doctors who are willing to assist, I think that may be different.
Oh, how often do you have a patient who brings up the religious aspect of it, who says, you know, I'm in terrible, terrible pain, but I don't believe it's that I should, you know, I can do this. I think I want to do it, but I don't think I can do it for religious reasons. Or do you bring those reasons up to them?
Actually, it's really something that very rarely comes up directly. People inquire it indirectly, and that's important to keep in mind once people start asking about the meaning, what's happening to them, why is this happening to me, what did I do wrong. That's when you really have to start a conversation. At times they ask me where do I stand on the issue. At times they ask me if I would prescribe. And again, you know, I try to answer with more questions to better understand what drives the question.
Do you ever answer either of those questions?
In the end, I will give my bottom line, yes. And that's the fact that in 20 years of practice, I really have not had a case where I really felt compelled that this was the appropriate course of action, or that I was convinced that.
Someone wants a comment on this. If I go into a hospice program, that means I cannot do suicide to relieve horrible pain, because the people at hospice would be afraid to help me do it and would have a legal obligation to stop me from doing it. Therefore, don't go into hospice if I want to keep my freedom to end my life. Isn't that
Well, that would be a terrible effect, a terrible deterrent, and very, very unfortunate, because everyone should have the gold standard of end-of-life care. And if they choose to advance the time of death because their suffering is unbearable, it should be truly the option of last resort. You know, it pains me so much, and I'm kind of embarrassed that it pains me so much, but I feel as though I have to apologize to people who might be watching this, who are themselves terminally ill, and are thinking that their dignity, their sense of personhood, that might depend on advancing the time of their death, and they might ask and they might yearn for the comfort and control of medication, and they hear Mr. Louie calling them repeatedly suicidal. I know how demeaning and depersonalizing that is. I've heard dying people say how much it hurts for them to be doing their best of making a rational decision for themselves and for their loved ones, and to be accused of being mentally ill and psychologically depressed. So you're not. The American Psychological Association does not think that people who are dying who have these thoughts are suicidal. Mr. Louie is wrong.
So let me rejoin. I haven't accused anybody of being suicidal. I haven't said that these people are mentally ill. What I'm saying is that I, as the Attorney General, and we, as the people of the state of Hawaii, have an obligation to our fellow citizens to do this right. If you want to have the right to have assisted suicide, if you want to have the right to have a physician aid somebody in dying, then fine. Let's go to the legislature. Let's have an appropriate program. Let's have it with safeguards so that we avoid abuse. Let's make sure that we have the appropriate safeguards to avoid all of these bad outcomes. If people want to do it, that's fine. The state of Hawaii has chosen not to do it so far, and I stand here to protect the citizens of this state from being abused, from being hoodwinked, and from being pushed into outcomes that they may not want to do because there's somebody close to them who's trying to urge that. And so I will do that every single time and every single day, unless and until the people of the state say, we want to allow this.
What the people of the state say, however, when you ask them, should government come in and put in a lot of bureaucratic constrictures, or should this be a personal, private matter between dying patients and their doctors? 90% of them say it should be a private matter. We should trust doctors. There is such a thing as a clinical practice guideline. There is such a thing as a standard of care for aid in dying. Doctors are bound to follow that standard of care. Those are the guidelines. Those are the safeguards.
You've never heard of physician malpractice? You've never heard of doctors who don't obey the rules? I'm sorry.
Well, in that case, no statute would help, would it?
Well, in the meantime, again, for the audience, and I agree that this is a very important issue. If you are suffering, you go to a great doctor like we have here on board, and then chances are you will get relief. But in the meantime, with your advance directive in Hawaii, we do have a block that indicates that I want pain medication sufficient even if it should hasten my death. Now, that's not illegal. That's provided in the statute. So at a minimum, for those of you who are suffering, you should be assured that that the suffering can be addressed, and there is nothing illegal about marking that box on your advance directive. It's a suggested format in the statute, and I would say to make sure that the person that you have as your agent in that healthcare advance directive also knows what your desires are, especially with respect to pain relief.
And I agree with that. I agree with that you can have palliative pain medication to relieve suffering. I just disagree with the idea that relieving suffering by killing someone is somehow palliative.
But when you add that terminal or palliative sedation or total sedation, we're right on this fine line. What is it? What is your intention? Okay, the doctor's intention is it's to address the pain under those circumstances, but the doctor absolutely knows that person's going to die when you do that. So is it either hours or is it days? And so I think that's where we are here.
It's a fiction that you can separate knowledge and intention. You can't have certain foreknowledge that this will be the impact of what you do and not also intended. And I think that there's actually more distance between the physician and an intended death with a prescription that's written than with pulling a feeding tube or disconnecting a ventilator. That's 100% certain. The doctor is taking an action, the patient will die as a result. I think that actually should be subject to the kind of regulation that Mr. Louie suggests.
I disagree with that because they are, when you have a feeding tube, people are prolonging life. It is an artificial way to prolong life, and then you stop prolonging the life. That's very different from a person who's living, breathing, and then you say, here, take this pill, and you'll end your life. That's a different qualitative matter.
But a faster way is to remove the respirator, which is also legal. It's completely legal to take off the respirator and you're dead in 5 minutes.
Jim, this has been fought through the U.S. legal system since the 70s, since the Cleveland case. So
and we're still
I'm not sure why are we talking about. It's a very well-established legal, moral, ethical framework that people do have the right to refuse treatment.
Absolutely.
Even if it's life prolonging.
I agree. I think everybody agrees.
We're talking about it because Mr. Louie talked about abuse and that we need a lot of statutory rules and regulations in order to prevent abuse. And what I was saying was that we have things that are considered a constitutional right that are much more subject to abuse. Taking a ventilator off or a feeding tube off is much more likely to be abused than somehow it's really impossible to do, to force someone to ingest medication that they don't want to ingest. That's just an impossibility.
Is there any legislative action on the horizon for the next legislative session? Who might take the lead for change of the law? Counselor,
well, the governor's package, and that's, my office and the governor's office and the administration have not proposed new legislative action in this area. But any legislator could propose that. The Senate, the House, it could come up. Any citizen could ask their legislator to introduce some legislation. But I'm just not aware of it.
But somebody writes in, good debate. However, you can go around in circles on this issue forever, as we have here in Hawaii, at least since 1996. Right. So if this is so controversial, why doesn't the Attorney General, David Louie, approach the legislator to set in place laws for best practices and revise the current state law that is over 100 years old? This issue will not go away. Come on, Louie.
Thank you. I'll consider that.
Come on.
And the legislature so far has decided not to do that.
Well, I'm thinking that if there's a second term, maybe it'll be more palatable for the governor to support this.
Not palliative, but palatable.
Palliative. Very good, very good. But I think that if we could have a test case without a deceased individual, that would be great. But how do we test your theory versus other theories on this manslaughter case without a deceased?
Well, that's the problem is that courts don't engage in giving advisory opinions, and if somebody's dead, then we're going to look at the circumstances as to how they died and determine whether or not there was manslaughter or not.
And hopefully we could get to a resolution rather than pursuing that avenue. But I think it's an intriguing point where we do have at least one doctor I understand who came forward and said that if there's a patient out there, he'd be willing to test the system. And I don't know where that is now. Do you have any knowledge on that?
Well, I'm not going to talk about the clinical experience except to say that, yes, physicians in Hawaii are writing prescriptions for a palliative purpose to empower and comfort dying people. They hope that these people don't ever take the medication, and they often say that when they hand the prescription to the patient. But the purpose is not to cause the death, certainly not to cause a suicide as if this dying person is suicidal. The purpose is to comfort and empower.
Sheila in Kamoela writes in, I just want to remind the panel to not forget about the spiritual part of dying. Aside from the medical, hospice is a wonderful organization that helps people pass in their own time on the right amount of medication and letting them go through the spiritual process of dying. Any comment on that?
I agree.
That's been your experience. But hospice has its own rules, doesn't it? I mean, is that, I had a brother who went through hospice care, and I was around for part of that, and it was not, he felt he gained very little from it, from them.
That's unfortunate. Also, it's not uncommon, and the reason for that because hospice is the way it's set up by law is a benefit, a health benefit that people can utilize in the last 6 months of life. The reality is that most people utilize it in the last few weeks of life when time is very short, and it really becomes a huge challenge to support the family, relieve physical symptoms, relieve emotional symptoms, guide people through the spiritual journey of facing their own mortality, which is one of the most complex challenges that humans have.
I want to tell you that the overwhelming opinion of people who are commenting here is that they feel that people have a right to some sort of help, assistance in dying, and that they should be able to choose the way to do it. But we are PBS, after all, remember that.
Well, the polls would verify that as well. I mean, the poll is that 90% of Hawaii voters believe that physicians should be able to write prescriptions for aid in dying, and that the government should not be intruding itself in these personal, private decisions.
One of the problems of healthcare, of course, I hate to bring up the dollars and cents part of it, though, is that, 5% of the population in the last part of its life is using up 50% of the healthcare, right? Isn't it something like that?
It's a huge disproportion. We really don't spend enough early on in the course of illness, and spending and overusing technology accelerates at the end of life. And the problem with that is not necessarily the amount we spend, but how we spend it.
And I've got to cut you off. I'm sorry, but I thank you very much for a spirited discussion. As we said, we'll come back next week and for the next 3 or 4 years and argue about this. Thank you very much for being here there. On the next Insights, how can we provide public access to beaches while still protecting private property? In Hawaii, access to the ocean for fishing, surfing, and cultural practice is a universal right, but sometimes homeowners or landowners attempt to deny that access. How do we balance the rights of landowners with those of oceangoers? Is Hawaii doing enough to ensure public access to its beaches? That's next time on Insights on PBS Hawaii. I'm Dan Boylan. A hui hou.